The Securities and Exchange Commission and financial institutions are facing a significant challenge in the cryptocurrency industry as a result of Ripple's top legal officer marking the first anniversary of the XRP without releasing a security statement. An important turning point was reached when the Supreme Court decided that XRP does not qualify as a security under the law. This verdict, which confirmed the SEC's egregious contempt for the law and its chairman, Gensler, too. Undue power was followed by a number of lawsuits, one of which was filed by Binance. In light of the fact that the United States of America is sliding further and further behind the rest of the world in terms of crypto laws, lawmakers on both sides of the aisle are becoming increasingly upset. Ripple and the industry as a whole will continue to grow despite Chair Gensler's resignation, as the court's decision that XRP is not a security will not be altered. This is despite the fact that the SEC has stated that it will not fight the conclusion that XRP is not a security. In the case between the Securities and Exchange Commission and Ripple, the SEC continued to lose after the summary judgment finding. It would appear that the Securities and Exchange Commission is attempting to ascertain, with regard to the regulation of cryptocurrencies, whether or not a token is beneficial. In contrast to tokens that have no practical application, the Securities and Exchange Commission is determined to prohibit tokens that have some kind of practical application. The current chief of the SEC, Gary Gensler, is dealing with two significant problems. To begin, here is his strategy for regulating blockchain technology and Bitcoin. In addition, he had the intention of incorporating an excessive amount of politics into the actual business of U.S. securities. Concerns of his include financialization, as well as the risk that a significant portion of cryptocurrency content is intrinsically fake. When it comes to evaluating how users interact with the utility of a token, authorities should proceed with caution. There is a significant degree of dependence on the utilization of blockchain technology for the continued existence of one of the most recent companies to enter the social media business. Due to the fact that many businesses employ high-utility tokens as a verification technique, it is challenging to compete with established participants in the industry. This gives rise to the question of, while other significant efforts were permitted to proceed without any obstructions, why XRP was picked out for analysis and investigation. On the other hand, Hester Peirce, another commissioner, is of the opinion that the SEC's enforcement policy is ineffective, not only for the industry but also for the limited resources that the agency has as a regulator. His argument is that a fresh generation of CC officials ought to be involved in policymaking rather than enforcement, and that a reset is required. Lastly, the SEC's plan for regulating cryptocurrencies is to support the development of stymine while ignoring the demands of the sector. In order for the cryptocurrency industry and market to flourish, the Securities and Exchange Commission (SEC) needs to adopt a firm stance on enforcement and reevaluate its rules. This film focuses mostly on the issues that have been plaguing the Securities and Exchange Commission (SEC) and banks, as well as the debunking of Bitcoin. In an effort to protect giant banks from threats such as leaning on a token devoid of, the Securities and Exchange Commission (SEC) has been concentrating its efforts on the digital asset sectors, particularly Ripple and XRP. As a consequence of this, federal officials have initiated a concerted attempt to discredit the industry. Because of the exceptions to SL 121 that the Securities and Exchange Commission has given, a number of the most important banks in the United States have been spared from the penalties that are associated with providing custody services for Bitcoin and other cryptocurrencies. Unlike non-banks, banks are able to provide a higher level of assurance on the security of their customers' assets since they cannot be compelled to declare bankruptcy. However, the problem with this technique is that the Securities and Exchange Commission (SEC) is picking winners and losers in the traffic sector, just as it did in the market for decentralized finance DeFi. As a result of the exceptions to SL 121 that the Securities and Exchange Commission (SEC) is providing to a number of big American banks, the assets of customers will be preserved in the event that the bank fails. It is good news for cryptocurrency markets since it boosts security, because banks have a structural advantage that complies with CC requirements. This is because banks have a structural advantage. Contrary to appearances, this is nothing more than selecting winners. The clandestine operations of the Securities and Exchange Commission (CC) are preventing the public from seeing. Large banks such as JP Morgan, Bank of America, Citi, and Citi. These enormous firms continue to amass wealth and expand their operations, despite the fact that the economy as a whole is in a state of flux. To a lesser extent, Hester Peirce has not achieved much either. The video gives the impression that she must undergo a reset in order to increase her chances of being considered for the chair job. If anything, the film gives the impression that a new agency consisting of Web 2 and Web 3 performers could be able to push the industry in the right direction. As a way to commemorate the one-year anniversary of the XRP, the film also includes a discussion by the chief legal officer of xrp+ripple. Despite the fact that the essay does discuss security, it does so in reference to the debanking of Bitcoin rather than the cryptocurrency itself. Last but not least, the SAC has been concentrating its efforts on the digital asset business, specifically Island XRP, in order to protect large banks from any threats. This has been going on for more than 4 years, and the industry is currently experiencing difficulties as a result of the effort that the ESCCC is putting into granting exceptions to SL121. The identification of an alternative agency that is capable of guiding the market in the right direction and is comprised of Web 2 and Web 3 players is of the utmost importance. Just to summarize, the film draws attention to the ongoing issues that have been plaguing the Securities and Exchange Commission (SEC) and banks, including the need to refute the claims and begin afresh. In an effort to address the ongoing issues that plague the cryptocurrency business, the video focuses on the challenges that are faced by financial institutions and the South Carolina Securities Exchange SCSE. Once the SEC made the decision to issue summary judgment in the Ripple litigation, it marked a significant turning point in the legal climate. This decision established that XRP is not a security, which was a significant accomplishment. This is during Gensler's tenure as chair of the Securities and Exchange Commission (SEC). This verdict acknowledged the SEC's overreach and lack of true devotion to the law. The Binance case was one of many that resulted from this ruling. Given that the United States is falling further and further behind the rest of the world in terms of crypto legislation, lawmakers on both sides of the aisle are becoming increasingly irritated. Despite the fact that the courts have served as a necessary check on the actions of the Securities and Exchange Commission (CC), it is intolerable to insist on token-by-token clarification through endless litigation. Ever since this verdict, the Securities and Exchange Commission (SEC) has been on the losing end, and it appears that their guiding philosophy when it comes to the regulation of cryptocurrencies is whether or not a token has any purpose. It seems as though they were determined to prohibit tokens that offer some benefit while ignoring those that offer no benefit at all. This raises questions about the integrity of various crypto content as well as the financialization of the cryptocurrency. On the other hand, if a token serves a purpose, the authorities ought to proceed with caution when it comes to user interaction and the impact that it can have on purchasing patterns. There is a significant reason to be concerned about the targeting of XRP, because a significant number of the next social media competitors will require blockchain technology in order to function, due to the fact that high-utility tokens are frequently used for verification by businesses. It is difficult to compete with the market leaders that are currently in place. It is perplexing as to why XRP was singled out while other significant initiatives were allowed to proceed untouched. Hester Pierce, the commissioner of the Securities and Exchange Commission, said that the agency's enforcement strategy is inadequate, given the limited resources available to the SEC in its role as a regulator, both for the industry and for the SEC itself. Because the SEC's harsh approach to enforcement problems is poor policymaking, Hester believes that a reset is required before the situation can be resolved. He believes that a new group of SEC staff ought to be involved in the process of policymaking rather than administration of enforcement. In conclusion, the Securities and Exchange Commission's SEC strategy for regulating cryptocurrency has been degrading ever since it issued its summary judgment finding in the Ripple dispute. In light of the fact that the enforcement-based approach to regulation taken by the SEC is not beneficial to either businesses or regulators with limited resources, policymakers should prioritize the development of rules rather than the enforcement of existing ones. The system has to be reset.